Good afternoon and welcome to the BW event panel on India's labor codes that have moved from a decisive legislative intent to an operational reality today. Our focus today is not on what the code says, but on how it is reshaping business decisions, legal risk, and workforce strategy. Today we have our eminent panel of experts, Mr. Atul Juvle, Mr. Gyanendra Mishra, and Mr. Abhinav Rastogi, who all were just introduced to all of you. So what we have done is we've structured our discussion around each code. We'll try to wrap it up as soon as we can, but there are 4 codes and there are quite a few questions. And we'll dive into the practical implications, challenges, and strategies for implementation, which I'm sure are questions that everyone has. So we'll begin with the code on wages, and I'll start with Mr. Juvle. Mr. Juvle, what practical adjustments do organizations need to make while recalibrating wage structures to protect both margins and morale while remaining compliant?
First of all, thank you very much, BW and Dr. Batra as well as Doshi for inviting me. And really, it's a great start in the morning with Batra's keynote and also 2 sessions, wonderful sessions. So there is a liability on us to make our session also better. So margin and moral. First of all, actually codes is a really wonderful movement in the social security of India. Because when we talk about, when people are going abroad, one of the main reason is social security. So I am not saying that social security will improve drastically, but it is a baby steps. And I will cover that on the wage part of it, moral and margin, where what is the question. So when the particularly in the proposed code, it is said that 50% has to be basic, and if the variable portion is more than 50%, it will be added to basic. Now how does it work out? Is the there are 2 parts I want to, one more part I want to include is the gratuity also, because it's a part of wages. So if we are to restructure the wages, important is that we ensure that while restructuring wages on the basis of the code definitions, we have to ensure that first of all take-home salary is not reduced, because that will take care of that is really hurting to the moral of all the people, including young and old, whatever it is. Because we are concerned with what comes as a SMS final credit to my account after tax, whatever deduction. So that should be ensured that to keep a moral. I have seen in my career 3-4 incidences where people were not accepting manager position because take-home salary was getting reduced once they become manager. So that should not happen. That will be a dampening sentiment, particularly for the youngsters. The reason is that for them 1,000 rupees count. 1,000 rupees or 2,000 rupees count, not for the people who are earning more than 5 lakhs rupees. It doesn't matter. So most important for the moral, because moral keeps the company's productivity on the high stage. If moral is down, then company cannot survive. Even if you make some kind of particularly savings on the net profit side, but it is only for the stock market. Your progress depends on the moral of the employee. So moral, I said that, and it is wonderful in the code that one of the most I like that is the gratuity. Gratuity was becoming dead, because today we know that nobody is working. Means I will say that 80% people leave the job between 1.5 to 3 years, 3.5 years, or maybe 4 years. Even my suggestion in the company was not to celebrate the people who have done 25 years, but my suggestion to the companies was to make the people more celebrity, those who spent 5 years in the organization. So gratuity will become a real aspect for the fantastic aspect for the wage revision. Reason is 15 days salary for 1 year is really a great when you lose a job. When you leave a job, that's not a problem. But when you lose a job, 15 days makes a lot of difference. Secondly, the wage structure, which will become a 20%. If I say that the 2 months or 3 months notice, it becomes 20%. So almost a person who is terminated will get at least 3 months legally payable compensation, which is a good for when you are in a trouble. On the company side also I wanted to talk. I see there are marginal hits will be there in the payments. The reason is that when you want to keep the moral high, marginal hits will be there, but it will be temporary because it will create a long-term impact on your business and progress also. So, yes, companies and employers have to redo the calculations, redo the wage structures, but my suggestion is that they should not put the people on the minus side, which will impact the moral and which will impact long-term success of the business. I love this actually because they have given this the calculations also. So it's a win-win situation for both. Yes, with some marginal cost to the employers, but it is good for the sustainability we talk. Sustainability depends on the employees because organizations cannot do sustainable business without employees.
Thank you. So as we can take away from this, balance is key. And once you are looking at restructuring of your wages, try not to reduce the take home because that's important for all your employees. And possibly a clear communication will also add to resolving any risks that could come with it if there is going to be a reduction in take home. So with that, I'll move on to Mr. Mishra. Mr. Mishra, what do you see as the highest likelihood of disputes under the wage code, and especially when we're talking about wage restructuring? Are they legacy arrangements? Will it be, the bonus payouts, the allowances? So where do you see the likelihood of disputes arising?
No, thanks, Pooja, and thank you, Business World and Business Legal World, for organizing this very pertinent conference. So I think that's a very important question, and the very scope of dispute is arising the way the code has been implemented. So the real issue is not to, discuss whether the changes or the codes are good, but the real questions are we ready for that? Since no time has been provided for the corporate to decode and then implement and restructures, which requires a wide-scale restructuring of various policies, compensation and benefits, payroll processes, etc., etc. So there is a big confusion when to start and when to finish, because the code has been implemented like for code on wage. Now this law now completely repeal all previous laws. So as on today, when you look from the effective law perspective, all old laws are repealed. New law from the 21st November has been enforced, but the rule has yet not come, so you don't know how to enforce that. So what is going to happen in the interim is not clear. There's a lot of confusion. The clients are coming to us and asking what to do. Suppose if today someone is going resigning or service is terminated, how to deal with the gratuity? Whether now we need to give the gratuity on an enhanced wage or the original wage. So there is much confusion, and that confusion I think will start leading to a lot of disputes because, so that uncertainty was one of the most important things that need to be addressed and which has not yet not been addressed. On the other hand, and I am speaking on a larger, scale. I think nobody questions the relevance of these codes. They were long due, and it is really a very progressive piece of legislation. But the question is that whether the appropriate consultations, which is very important for success of any legislation reforms, more particularly on the labor, giving there the different stakeholders into it. So I believe that, the consultation process, which would have helped in seamless implementation of the law, has not been done enough, if it has done at all. India provides a framework under the India Labour Conference for discussion on the labor issues where all the three different stakeholders and more than three different stakeholders are present. But you know that since 2015, no ILC conference has taken place. And look at the history when these codes were passed in year 2019 and 2020. Most of these codes were passed when the parliament was in turmoil because of the agitation on farm laws. So the question is that the way you look at it, it depends on your vantage points, that you look at it as in political expediencies or procedural shortcut, but the enough deliberation which was required to build a larger consensus lagged as far as this code is concerned. And that is why you see there's a large scale protest. You know, the all trade unions have threatened a nationwide strike from the month of February to challenge the implementation of labor code. Today, I heard I was reading in the paper that your main opposition party, Congress, is also telling that we will oppose the implementation of the labor code. So that is very unfortunate because, as I said, it was in long demanding and long required need of, reforms in the labor laws, and it is a really positive states towards building a, progressive labor law regime which helps or creates an architecture which creates a balance between the enterprise and the employee's right. But unfortunately, because of certain aspects that I highlighted, the implementation is too much in question right now, and a lot of uncertainty is looming around how it will go. Now coming back to Pooja's question, that where we see, so as a lot of, scope for or the, dispute. So as you see, the wage definition, now the major change which has basically happened is that now your wage for all your social security benefit is capped at 50%. So the new definitions is a positive step in the sense that it clearly defines the component which will be considered in the wage and the components which are excluded from the definition of wage, which may make the part of your CTC. But the catch is, the seismic shift which has happened is that now whatever way you structure your CTC, for social security calculations, the 50% of your CTC will be treated as your wage. And that requires a large scale restructuring of the compensation and benefits. And I see that the legacy issue will be where the major challenge or major dispute will happen. Because mostly in the service sector and corporate sector, you will see that the tendency to construct the CTC is in a way that a large portion of your emoluments are parked in, performance incentive schemes or variable pays and ESOPs, etc., etc. And now when the employer will try to grapple with this change in the sense that they will try to reduce your variables and allowances and increase your basic pay, the challenge will be to deal with the legacy structure, how to go about it. Obviously, for a senior level employee, you will have to build the consensus, as Pooja was referring to. So the consent and consensus would be the key, but still there would be an element where, the employees may not be satisfied with. But when you are falling in the workers category, any change in wage structure, requires the process, legislative process to follow, which is the 9A process, what we call, which again talks about the notice and consultations. So how you are going to do and how to create a balance, what Mr. Atul was also referring to, that where your take home is not reduced, but the cost of employment also is not increased beyond a proportion, because we must understand that the very basic of this law was for ease of compliance, ease of doing business, and to attract the larger investment in India. The cost arbitrage is one of the most important factor. And when you look around your competitor in the field of attracting the foreign investment, large scale manufacturing activities, countries like Vietnam, Cambodia, Thailand, where the labor cost is much less than India. How to create this balance and how to ensure the regulatory compliance and the the least business disruption is going to be a challenge. And this is where you may see a lot of disputes coming in.
Thank you. That's quite a few points to think about, and I think the most important one is that legacy arrangements that were never challenged earlier could be the weakest link. Of course, with the current uncertainties and what we're seeing in terms of the pushback on the labor code implementations, the labor codes clearly are here to stay. So the next one is for you, Abhinav. What future-proofing principles should employers adopt today to minimize litigation tomorrow?
Sure. Thanks, Pooja, and thank you, BW, for organizing this. Well, if I were to distill this into one legal principle, it would be that wage restructuring should be based on substance and rationale rather than just doing some arithmetic or some calculation around it. That's one of the key take of the entire recalibration of wage structure. So to give you an example, we are doing a live matter where the wages are approximately 70 to 80% of the total remuneration. And that's a common question we all get, that how do we kind of get it into a wage bracket of 50%? So firstly, most employers, they are kind of taking refuge to a specific component which is prescribed under the excluded components, that is sum paid to defray expenses. So I'd like to touch base upon that point first, that any expense or any allowance or anything paid to an employee would not automatically fall under that exclusion. There has to be some rationale, there has to be a specific role for which that amount is paid. For example, a legal allowance given to a person who is in the legal department could be excluded. But if you apply this universally across the establishment, it would not fall within the purview of the excluded component. In a sense, what would that mean? That it would open your wage restructuring to scrutiny, to understand why this component was paid, and it should be included. So what I'm trying to say here is that it should not just be arithmetic. Proper reasoning, rationale should be adopted when you are doing that restructuring exercise. Also, importantly, you should check that while doing this restructuring exercise, it should not happen that your statutory contributions like your PF, where the threshold is 1,800 rupees per month for 15,000 employees who are earning up to 50,000 rupees, that should not get compromised, in the sense that if that reduces, then again, you're opening a Pandora box to scrutiny. So in a sense, everything should be from the perspective that how an organization functions, what rules could fall to have a particular allowance which could be paid to them, which could fall within this excluded category, so that your liability for wage terminal benefits like gratuity, everything gets reduced to an appropriate amount, up to 50%. So yeah.
Yeah, that's quite key. Compliance today must be designed keeping in mind tomorrow's litigation risks, and rationale is definitely one of the important factors here when you are looking at making changes to your wage structure specifically. I'll move on now to the Industrial Relations Code, and I'll start off with Mr. Juvle again. Do the revised thresholds for standing orders and retrenchment and closure genuinely improve agility in restructuring and workforce planning?
Yeah, actually, answer is yes also and no also. The reason is we have done that one number of 100 magical number to 300. So that is one of the major, and I think it's a good start. The idea is that if somebody is starting a business, why they should go to government for the approval for closing of the business. Because that is one of the dampening, and then particularly delaying the process of restructuring or retrenchment. So this is a good move that 100 number has moved to 300 because it is required. Now with the change in this ecosystem where we are having so many people on the roll, that 300 number is also very less actually. If we talk about the platform workers or we talk about the gig worker, gig side of story, the numbers are very huge. But it will give some kind of relief. We cannot expect that everything will happen in maybe one go. So I feel that there are many suggestions which have come in the particularly or maybe enactments, which will benefit the reclassifying and redoing the total structure where the agility will be there in some cases. I am not saying that it will be all across. Because if I have businesses going in the loss, I cannot invest my time in government permission to close down. Though finally it becomes bankrupt and then it closes down rather than I can do it at a right place so that people are also informed transparently. Because the problem is the transparency and then companies or employers are bound by the rules of the particularly going to taking the permissions and all. We need to move out of that permission, Raj. We have moved a lot actually, but still there is a room balance. So I feel this is a good start. One thing I wanted to comment on this, my panel, particularly members, the movement is also, that today we are into particularly a situation where the labor codes are published and we are waiting for the rules. One of the litigation, the particularly increasing litigations will be which to be followed. And that's where I feel that they should be taken as a guidelines rather than law, where as you know that SEBI provides a guideline and you have to comply. So companies should not wait because that's a common practice all across the world, not only in India. When the law comes and there is a time, people feel that let's wait for the last announcement. Till that time, I will take that benefit. That approach should not be there. That approach will dampen the particularly sentiment, and we want to grow. If we want to become particularly second country in the world, definitely we have to move forward with the forward guidelines and all. So if the companies take it seriously, I think we can see a light early than rules comes.
Thank you. That's interesting to know that numbers help, but I suppose planning and procedure compliance will also be equally important when you're looking at any workforce restructuring. Moving on to Gyanendra, which provisions under the IR code are most likely to be tested in courts and why?
So, I think, the first provision, I know that going to be challenged in the court is the increase of the threshold from 100 to 300. And there would be the constitutional basis for that as well, that India being a socialist country, and there are the directive principle of state policy which says that the government's responsibility is to protect the livelihood. And the data shows that a large number of manufacturing industries still fall within 100 to 300 of the category. So it may be challenged that the government has left the large section of lower level of workforce at the mercy of the employer, and basically by increasing the threshold has introduced the concept of hire and fire within the employment scenario. So therefore it will be the test of the constitutionality. The Supreme Court in its earlier decisions have held valid the threshold of 100, but whether now it will be tested in the same way when the threshold is 300. And more particularly, the wage code gives states the liberty to even increase this threshold beyond 300 to any level where they wish. So there may be a competition among the states who want to seem as a progressive state and wants to attract investment to increase the threshold even much higher. So that's the one thing which I believe will be challenged. The second challenge may be now the extension of a standing order across the establishment. Earlier, the standing order was only applicable, as you know, to factories and other industrial establishment. But now it has been made across the board, even to service sectors, IT sectors, etc., etc. But there is no corresponding model standing orders, because when you look at the current standing order, there is only one model standing order, which is more tuned to the manufacturing sector rather than the service sector, IT sectors or technology sectors, etc., etc. And so how to harmonize their service rules with the model standing order, and when the model standing order go for certification before the authority, the challenge to harmonize their existing rules, which many times are guided by the global policies of the companies with the model standing orders and all that, you will see a lot of challenge happening there as well. On the bonus front, you see, again, there could be a challenge, because as far as the provident fund is concerned and the threshold limit, payment of wages, minimum wages, all the threshold has been taken away. But as far as the bonus is concerned, though the current limit of 21,000 is not disturbed in the sense, but there would be a further notification that what would be the limit for SAT. So there could be a challenge on that as well. So there are multiple issues where I see that the challenge may happen, Pooja.
Right. I mean, there is no law where there will not be a challenge, especially when it comes to employment law. And the IR code is definitely a code where jurisprudence will shape the business reality much more than the statutory text. So Abhinav, how can employers structure policies and documentation to avoid disputes rather than merely defend them?
Sure. So I'd like to share an anecdote here of a FICCI event which Pooja was moderating, a recent event, a simple line said by a trade union that stayed with me. When HR fails, IR triggers, correct? So that's a very powerful line, and that's what the entire realm of industrial relation code has been. From a reactive approach to litigation to a preventive measure. How there is a mechanism now for grievance redressal mechanism, which is outlaid in the code now. That is one. Then your trade union representation becomes very imperative. So in a sense, I do not think that we need to overhaul the entire policy framework for employers. What they need to do is that they already had global policies in place. They need to just have reference, or they need to localize it from Indian employment law context, have a representation. For example, there was a grievance redressal mechanism in an employer's, typically it is a part of their employer's handbook. Now just just go a step ahead and have representation or have a reference to your non-managerial employees as well. Similarly, the standing orders, like my fellow panelist was speaking, is the heart of industrial relation now. They have a disciplinary mechanism, they have an appellate authority. So just ensure that you have a robust system, and those system is evenly played out to give equal opportunity for employees to set out their grievances so that you mitigate the litigation aspect.
Thank you. Prevention through policy design is definitely far more effective than a post facto legal defense, which comes with a lot of added cost. Right. So now we move on to the OSH code, and we have one more, so we will move on quite quickly, and we won't keep you from lunch. Mr. Juvle, this one's for you. How are companies leveraging technology, audits, and training to ensure consistent safety practices?
Thank you. Actually, OSH code is really, we need a mindset change for India. And particularly it remains with every Indian, not the code. The reason is that we don't take safety still seriously. That's where I feel, because I have seen, and recently Goa incident is one of the examples that we don't take safety seriously. So rather than having the codes and rules and regulations, each one of us has got some kind of obligation that we should look at the code. How do we take safety seriously? Now, coming to the OSH code and the audits are improved a lot, because now it is moving from assurance audit. Assurance audit is just I take 5% sample and give audit report. Now it is coming to 100% level because of the artificial intelligence, because of the machine learning, and so it will improve. I have seen a problem when we wanted to catch a worker in the factory doing wrong thing. But today it is CCTV, we can get the evidences and which he or she cannot defend in the court of law. So audits will become real-time audits, and we can have while I started with the negative sentiment on the safety, but corporates are becoming very serious on the safety, and I see that when I'm in a board of 6 companies and where we talk safety first rather than the business, because that's a kind of the particularly importance is given to safety code. So audits will become real-time story, and then there will be less. We were talking about the litigations. The litigation becomes zero, because if there is a evidence on the board, actually, we can definitely take the actions. Because in labor laws, particularly, we talk about the manufacturing somebody too, but there are also new type of businesses also have what litigations, because there are no evidences. If evidences are there, I don't think there can be appeal. In the morning we talk about the appealability is one of the minus point in Indian judiciary system. So I am positive on this side actually, particularly audit side where there will be real-time audit.
Thank you for that. It's encouraging to hear that safety compliance is becoming more and more important nowadays. Gyanendra, the next one's for you. What safeguards can organizations adopt to continue using contract labor without triggering adverse findings on core activity engagement?
So for that, again, I will say that you basically need to change the mindset, that, we need to understand that the engaging the contract labor is the reality of the way the modern business works, But now the law puts certain clear obligation on the employer to engage the contract labor where it seems necessary to engage the contract labor and not to engage them in their core activities. So that mindset shift, seismic shift in the mindset where you see the engagement of contract labor as in cost measures rather than from the necessity perspective, that if I'll hire the contract labor, they will be hired at the lower cost than our regular employee. So please engage the contract labor wherever possible. I think that mindset need now to be changed, and you need to hire the contract labor where there are, and the law also now gives the instances where there is no regular and continuous requirement of the job. Where there is a continued requirement, you should engage the regular employee and give them the protections, statutory protections. So first of all, in my opinion and my advice would be to change that mindset, evaluate your entire contract labor, engagement policy and processes, and try to engage the contract labor where it is required, where it is necessary, where you don't have the required skills within your regular employee set. And that will see the reduced, litigations and other aspects.
Thank you. So contract labor decisions and restructuring of whether or not you need to engage contract labor for core activity must withstand scrutiny. Of course, one has to go back to look at, are you engaging contract labor in core activity or not? What is core activity for your organization? And also whether, you can make that change effectively. Abhinav, where do you see the greatest legal ambiguity around leave encashment? There's a lot being asked on leave encashment with the changes in the labor code, and how should employers mitigate that risk?
Sure. So yeah, I wouldn't strictly call it ambiguity. Definitely there is an overlap. And by overlap, I mean that the central and state government need to come up with clear notification guiding employers. For example, right now, the OSH code talks about post 30 days of leave, employees have the right to encash leaves. Whereas the state-specific shops and establishment, which is a primary statute for condition of service, provides for leaves ranging from 45 to 60 days. Now, this is a dichotomy here. How do employers navigate through this? So a simple exercise is that you need to first map all your locations, all the state-specific shops and establishment statutes leave provided under those state-specific shops and establishments. When you have done that, and once you have come to a conclusion which is the most beneficial statute between the two. The idea would be to comply with that more favorable statute for the time being until the central government or the state government comes in and gives clarification. Another interesting point is, while OSH code, people are harping about the fact that post 30 days, the leaves can be in cash. But the definition of wages under the OSH code is very different to the definition under the state-specific shops and establishment, which is more of a very inclusive definition, that is gross wages. Here, it's going to be restricted to some limited amount because it only going to be it only will encapsulate your included components. So what I mean to say here is that a mapping exercise is very important. If you have multiple location, map it against the state-specific shops and establishment, map it against the OSH code. Once you've done that exercise, see what the wages component is under the OSH code, what is the wage component under the shops and establishment, whichever is more beneficial until the central government and state government comes with a clarification. Idea would be to comply with that for the time being.
Right, thank you. And I think to just add to what Abhinav said, there is also the component of, do you really need to encash the accumulation which one has gathered under the Shops Act, under the Labor Code? So that's the question that, we are grappling with right now. In my view, I don't think so, but then let's see what happens going forward. All right, the last one, Social Security Code. Mr. Juvle, have Social Security considerations begun influencing decisions on hiring models, outsourcing or gig engagements?
Yeah, if there is a clarity, so there will be impact on the outsourcing model, and certainly it's a welcome stage. As a welcome step, I already mentioned on this code actually. So I believe that this change in the mindset, and which is happening actually, because we want to become a stronger nation and everybody wants their own business in the growth scenario of India, and I think it is a welcome step.
Yes, this definitely reflects a broader shift in mindset, and compliance considerations will, going forward, definitely shape workforce architecture and not just HR policies as we engage different types of workforce. Gyanendra, which aspect of the Social Security Code represents the biggest break from the earlier regime?
I believe, this social security code, now there's a lot of confusion, but, the thing is that from the social security perspective, I think it is the least disruptive among all other code, basically. ESI, I believe, is where the most of the changes will happen, because now it has been, the application of ESI has now been made universal. Although the salary threshold has not been changed, but now there is no requirement for scheduled employment and geographical locations, and therefore this will give the larger coverage, and that's the biggest change I see, in the social security.
Right. And I think one more aspect that I could add to what Gyanendra just said is that there is an introduction of a limitation period for Provident Fund, which is, I think, the biggest help from an ease of business doing perspective. Till now we were looking at a possibility of a scrutiny or a claim or a Section 7A proceeding commencing right from the time an establishment was established, but now there is a 5-year limitation, and I think that's a welcome change for the industry. Abhinav, we wrap up with you. What risk-calibrated compliance approach should employers adopt while the framework continues to evolve?
Sure. So I'm conscious of the time and I'll keep it really short. The first one being that engagement of fixed term. That introduction has been made that they would be entitled to benefits akin to your regular employees. So that assessment needs to be done. In terms of another important aspect which I'd like to quickly highlight is about the gratuity. Don't wait for the last mile. The definition of wages is applicable as on date. There is no reason why an outgoing employee should not be paid gratuity as per the new definition. We are grappling with that issue. Pooja would echo with my views here, because this is a huge cost impact, right? From basic, which was about 20-30%, to what now it could be at least 50 and could be more. So we need to understand, don't wait for the last mile, get in touch with your auditors, assess the liability. Grandfathering may or may not happen. There is a lot of debate over that. But just be ready until all the rules or the rules, the state governments come out with the rules. Just have that agile approach. Do your wage restructuring, but ensure that you're ready for fixed term employees and gratuity payments.
Thank you, Abhinav, and thank you to all our panelists for their exceptional, thoughtful, and practical discussion. If there's one clear message today, it's that the labor codes are not merely it's not merely a compliance mandate. They're an opportunity for an organization to modernize workforce practices, strengthen governance, and build more resilient and future-ready enterprises. As the regulatory framework continues to evolve, those who invest earlier on in robust systems and transparent policies will not only stay compliant, they will also set benchmarks for responsible growth in India's evolving labor landscape. Thank you and enjoy the rest of the BW event.